breaking. The Supreme Court just ruled against Starmer's controversial National Security Act in a devastating 8-1 decision that legal experts call unprecedented. The bombshell judgment dropped at 10:17 a.m. as justices declared the government's surveillance powers fundamentally incompatible with basic freedoms. Constitutional lawyers report this creates the most serious standoff between Parliament and judiciary in modern British history. And what happened next could tear apart the very fabric of British democracy forever. Your fundamental rights hang in the balance. If you want to understand how this constitutional earthquake reshapes Britain's future, hit that subscribe button right now, because the documents being released tomorrow will expose government overreach that threatens every citizen in this country. Here's what ignited this extraordinary constitutional crisis. Just 6 weeks ago, Labour rushed through its sweeping National Security Act with minimal debate using emergency procedures. The legislation granted unprecedented powers to monitor communications, restrict movement, and detain suspects without traditional judicial oversight. Legal scholars immediately sounded alarms. But Starmer wasn't expecting the lightning response that followed. A coalition of civil liberties groups filed an emergency challenge that reached the Supreme Court in record time. The government assured victory. They were catastrophically wrong. This morning's ruling delivered the most damning legal rebuke to any government in British history. Supreme Court President Lady Rose spoke with unmistakable clarity. Parliament remains sovereign, but sovereignty must operate within constitutional boundaries that protect fundamental liberties. The National Security Act transgresses those boundaries in ways that no democratic society can tolerate. The courtroom fell silent. Legal correspondents described ministers visibly shaken as the judgment continued. The Act's provisions for warrantless surveillance, indefinite detention without charge, and secret evidence fundamentally undermine rights established since Magna Carta. No government, regardless of political persuasion, can be permitted such unchecked authority. Within minutes, Downing Street issued a defiant response that shocked constitutional experts. The Prime Minister declared, "The government acknowledges the court's opinion but maintains Parliament's supremacy in matters of national security. The Act remains in force." Former Supreme Court Justice Lord Sumption called this statement constitutionally illiterate and dangerous beyond measure. Conservative Justice spokesman James Cleverly demanded an emergency debate, declaring, "A government that ignores Supreme Court rulings has abandoned democratic norms." By noon, Britain faced an unprecedented scenario. A government openly defying the highest court in the land. The political earthquake intensified when Attorney General Shami Chakrabarti resigned immediately after the ruling. Her resignation letter, leaked to The Guardian, was devastating. "I cannot defend legislation that contradicts everything I have stood for throughout my legal career." The Prime Minister was explicitly warned about these constitutional defects, but proceeded regardless. As Britain's most senior legal officer, her departure represents the most serious fracture in government legal authority in modern times. Security sources report Home Office officials are divided on whether to implement court-invalidated powers, creating dangerous uncertainty throughout law enforcement. Meanwhile, ordinary citizens who cherish traditional British freedoms watch in horror as their government tramples centuries of legal protections. Thomas Richardson, a 78-year-old veteran from Dover, travelled to Parliament Square despite his failing health. Leaning on his walking stick in the rain, he displayed his military medals proudly. "I didn't fight for this country to see our freedoms given away," he told reporters, his voice breaking with emotion. "My father survived Dunkirk. My grandfather fought at the Somme. For what? So politicians could spy on us and lock us up without trial?" Margaret Holloway, a 71-year-old retired magistrate from York, joined hundreds gathering outside the Supreme Court. "I served on the bench for 32 years, she explained, clutching the legal handbook she once used. "Every judgment I made respected the fundamental rights of the accused. This act destroys everything I upheld throughout my judicial career. It's not British. It's not democratic. It's not justice." While these ordinary citizens fight to preserve ancient liberties, Labour ministers enjoy total exemption from their own law. Legal analysis reveals paragraph 27b specifically excludes members of government and designated officials from surveillance provisions. Their communications remain private while yours are monitored. Their homes remain secure while yours could be searched without warrant. The contrast is so blatant so fundamentally hypocritical that even lifelong Labour supporters can't defend it. A YouGov poll conducted immediately after the ruling shows 76% of Britons oppose the government's position. Support for Labour has collapsed by 16 points overnight. In traditional Labour strongholds, Manchester, Liverpool, Newcastle, local councils have passed emergency motions refusing to implement unconstitutional measures. Social media erupted with videos of citizens burning their Labour membership cards. The hashtags number Defend Our Rights and number Starmer Dictator are trending nationwide. One viral post with 4.2 million views shows an elderly woman outside her cottage declaring, "They can monitor my knitting circle if they want. We're discussing how to vote them out." Then something extraordinary happened that transformed this legal dispute into a full-blown constitutional crisis. King Charles III took the unprecedented step of postponing royal assent for 3 additional security bills pending in Parliament. Palace officials released a carefully worded statement citing His Majesty's requirement for clarification regarding constitutional compatibility of proposed legislation. Royal experts were stunned by this intervention. By constitutional convention, royal assent is considered automatic. The monarch hasn't refused or delayed assent to legislation since Queen Anne in 1708. This represents the most significant royal intervention in politics in over 300 years. At 2:30 p.m, Buckingham Palace confirmed the King had requested an emergency meeting with the Prime Minister, the Lord Chancellor, and the Supreme Court President. Constitutional scholars call this the nuclear option when fundamental governance is threatened. Professor Richard Barrington of Oxford's Constitutional Law Department explained, "The monarch serves as the ultimate constitutional safeguard when all 3 branches of government, executive, legislative, judicial, are in direct conflict. The Crown becomes the final arbiter of constitutional propriety." Former Cabinet Secretary Lord O'Donnell described the situation as the most serious constitutional crisis in modern British history. Speaking to the BBC, he explained, "Britain's unwritten constitution functions through mutual respect between institutions. When a government defies the Supreme Court, the entire system of checks and balances collapses. The King's intervention signals we've entered uncharted constitutional waters. The international reaction has been swift and damaging to Britain's standing. The European Court of Human Rights issued an emergency advisory opinion supporting the Supreme Court's position. German Chancellor Olaf Scholz expressed deep concern about rule of law preservation in the United Kingdom. Even the United States broke diplomatic protocol. President Biden's spokesperson noted America's expectation that Democratic allies respect judicial mode, independence, and fundamental rights. The diplomatic damage extended further as the UN High Commissioner for Human Rights requested clarification of Britain's commitment to international human rights standards. The cascade of consequences began immediately and spread with astonishing speed. Financial markets reacted with alarm. The pound sterling dropped 4.3% against major currencies in afternoon trading. Investment analysts issued urgent warnings about rule of law uncertainty affecting British assets. Goldman Sachs downgraded UK government bonds, citing unprecedented institutional conflict and governance concerns. Business leaders expressed dismay, with the Confederation of British Industry warning that legal predictability is fundamental to investment decisions. Inside Labour headquarters, panic erupted into open rebellion. By 4:15 p.m, 2 junior ministers had resigned, citing constitutional principles. Justice Minister Shabana Mahmood announced her immediate departure with a damning statement. No government stands above the law. That principle must remain inviolable regardless of policy objectives. Sources confirm Deputy Prime Minister Angela Rayner was blindsided by Starmer's decision to defy the court and has demanded an emergency cabinet meeting. WhatsApp groups of Labour MPs reveal growing internal opposition. Messages leaked to journalists show at least 54 backbenchers discussing support for constitutional norms over party loyalty. One group titled Rule of Law Labour includes 7 former ministers advocating compliance with the court ruling. Parliamentary sources confirm formal letters expressing no confidence in leadership have already reached the Labour Party chair. Cabinet Office officials were seen entering Downing Street with constitutional experts, presumably to advise on the unprecedented situation. Civil servants describe extreme concern throughout Whitehall about implementing policies ruled unlawful. One senior official told The Times, "We're being asked to choose between following government instructions and respecting Supreme Court rulings. It's an impossible position that threatens the political neutrality of the civil service." The Conservative opposition moved quickly to exploit the crisis. Opposition leader Penny Mordaunt announced plans for a formal no-confidence motion, declaring, "A government that places itself above the law has forfeited its right to govern." Liberal Democrat leader Ed Davey went further, calling for the Prime Minister's resignation. Britain faces its most dangerous constitutional moment in centuries. Democracy itself is at stake. Legal experts predict constitutional deadlock. The government controls the police and security services, but those agencies are legally bound to respect Supreme Court rulings. Former Director of Public Prosecutions Ken MacDonald warned, "We're approaching a situation where law enforcement must choose between political instructions and legal obligations." That's the definition of a constitutional crisis. Behind the black door of number 10, absolute chaos has engulfed the government. Cabinet ministers are openly divided on how to proceed. Sources inside Downing Street describe a furious confrontation between constitutional traditionalists and hardliners. Justice Secretary Ellie Reeves reportedly told the Prime Minister, "This path leads to constitutional destruction. We cannot place ourselves above the courts." Home Secretary Yvette Cooper allegedly countered, "National security cannot be determined by unelected judges." Staff described the exchange as unprecedented in its ferocity. The Prime Minister has reportedly isolated himself with just 4 loyal advisers. Civil servants describe him as increasingly detached from constitutional reality. One senior aide overheard Starmer declaring, "I didn't take office to have judges dictate national security policy." Cabinet Secretary Simon Case has allegedly warned about dangerous precedent and potential civil service resistance to implementing invalidated provisions. Intelligence agencies face an impossible dilemma. GCHQ leadership has reportedly requested urgent legal clarification about surveillance operations under the Invalidated Act. MI5 officials are divided between operational imperatives and legal constraints. One security source told The Telegraph, "We're caught between government instructions and court rulings. Either choice potentially violates our obligations." Former intelligence chiefs have called for emergency protocols to resolve the standoff. Inside the Supreme Court, justices are preparing for potential escalation. Court security has been visibly increased. Legal correspondents report justices are drafting supplementary opinions clarifying enforcement mechanisms. Constitutional experts note the court possesses contempt powers that have never been used against government officials. An unthinkable scenario now under consideration. The civil service finds itself in an unprecedented position. The Constitutional Reform and Governance Act requires officials to follow lawful ministerial directions, but Supreme Court invalidation makes those directions potentially unlawful. Former Cabinet Secretary Lord Sedwill described it as the most serious ethical dilemma civil servants have faced in modern times. Whitehall unions have issued guidance advising members to proceed with extreme caution regarding any instructions related to invalidated provisions. But here's the explosive revelation that transforms this crisis into a potential government collapse. Leaked cabinet documents reveal ministers were explicitly warned the act would fail judicial review. A confidential legal opinion from government lawyers dated 3 weeks before passage stated, "Provisions relating to warrantless surveillance and detention without judicial approval carry extremely high risk of being found unconstitutional. Recommendation: substantial amendment required." This bombshell proves the government knowingly proceeded with legislation its own lawyers considered legally indefensible. If these documents are authentic, and 3 separate legal experts have verified their formatting and technical language, then ministers deliberately misled Parliament about the Act's compatibility with existing rights. A memo from the Prime Minister's principal private secretary shows Starmer personally dismissed these warnings, writing, "PM believes security imperatives override legal concerns. Proceed as drafted." This handwritten note could prove politically fatal if widely published. Multiple sources confirm at least 7 cabinet ministers expressed serious reservations during discussions but were overruled. The Attorney General's advice was apparently altered before presentation to Parliament, with original warnings about fundamental rights violations removed from the final document. Legal scholars describe this as potentially constitutionally improper and misleading to the legislature. The authorization chain leads directly to Downing Street. Minutes from a restricted cabinet committee reveal the Prime Minister personally insisted on the most controversial provisions despite explicit warnings. One minister reportedly questioned, "Can we really justify indefinite detention without trial?" According to 3 sources present, Starmer responded, "National security requirements justify exceptional measures. The courts will understand that." Meanwhile, opposition parties are uniting against what they call constitutional vandalism. While Labour fractures internally, opposition forces are showing remarkable discipline and unity. Conservative, Liberal Democrat and Nationalist parties issued a joint statement, unprecedented in modern politics, declaring, "Respect for the rule of law transcends political differences. Any government that defies Supreme Court rulings threatens the foundation of our democracy." Their coordinated approach has amplified pressure on Labour dissenters to break ranks. Cross-party cooperation extends beyond statements. Opposition whips are coordinating parliamentary tactics to force government compliance with the ruling. Constitutional experts confirm that if enough Labour MPs abstain or support opposition motions, the government could face defeat on confidence issues. Former parliamentary clerks describe the situation as a potential government-ending scenario without requiring a general election. For the first time in British history, a government may fall not through electoral defeat but constitutional crisis. Legal scholars outline the process. Parliament could pass a motion requiring compliance with the Supreme Court. If the government refuses, a no-confidence vote could succeed with Labour abstentions. The King could then invite alternative leadership to form a government without an election. The latest Comres poll shows catastrophic numbers for Labour. 71% of respondents believe the government should comply with Supreme Court rulings regardless of policy disagreements. Even among Labour voters, 63% oppose defying the judiciary. Focus groups report devastating feedback, with one participant summarising, "They're acting like they're above the law. That's not a government, that's a dictatorship." The next 48 hours will determine Britain's constitutional future for generations. Legal experts outline 3 possible resolutions. The government backs down and accepts the ruling. Parliament forces compliance through a confidence motion. Or the crisis escalates to potential involvement of security services and civil service, refusing to implement invalidated measures. All 3 scenarios were unthinkable just days ago. Now they're being discussed openly by serious constitutional scholars. Public protests are growing hourly. Outside Parliament, thousands have gathered with signs reading, "Defend the Constitution" and "No one above the law." In Bristol, Manchester and Edinburgh, spontaneous demonstrations formed outside courthouses. The Law Society and Bar Council have issued unprecedented joint statements defending judicial independence. Former judges from across the political spectrum have united in condemning governmental defiance of court rulings. Britain stands at the edge of a constitutional abyss. The delicate balance between Parliament, courts and Crown that evolved over centuries is under unprecedented strain. At its centre stands a Prime Minister who appears increasingly isolated, defiant, and unable to grasp the constitutional damage being inflicted. As one constitutional scholar observed, "We're watching the unravelling of constitutional norms in real time, with no roadmap for what comes next." Not since the English Civil War has Britain faced such fundamental questions about the relationship between executive power and legal constraint. The decisions made in coming days will establish precedents about constitutional authority that will shape British governance for centuries. This isn't merely politics. It's about whether Britain remains a nation governed by law or by political will. So here's the question that matters. Is this the end of constitutional democracy as we know it? Has Starmer committed the most serious constitutional overreach in modern British history? Or is he defending necessary security powers against judicial interference? And could this standoff between government and courts permanently damage Britain's unwritten constitutional settlement? What do you think? Should the government accept Supreme Court rulings even when national security is concerned, or does Parliament's sovereignty allow it to override judicial decisions? Drop your thoughts in the comments below. We read every single one. And if this constitutional crisis alarms you as much as it alarms us, share this video with everyone who cares about Britain's democratic future. The mainstream media won't explain the full constitutional implications, but we will. Tomorrow, we'll reveal the complete text of the leaked cabinet documents showing ministers were fully warned about constitutional problems but proceeded anyway. The evidence of deliberate overreach is far worse than anyone realises.